Yes.
Well, I think when you break both, talk about the special position of children. I'm going to go through that. I'm just about finished that, but there are two things that I probably need to address. But I am conscious that time is pressing and the material is fairly fully set out in our statement of case. The 2 points that I'd wish to just emphasise in relation to children are firstly, partly because of the fact it is plainly relevant in interpreting the European Convention on Human Rights, is Articles 3 and Article 40 of the United Nations Convention. Article 3 is the provision that I suspect the court is very familiar with, which is the best interests provision. The provision that requires best interest to be a matter of primary concern. But Article 40 is particularly important in this context because it sets out essentially what is a key right of children in relation who appear before the criminal courts. And it is, I'm sure the court can read it for themselves, but it is essentially to be treated in a manner that takes account of age and takes account of the desirability of promoting reintegration. And for the reasons I indicated this morning, it's certainly our submission that in the particular context of the first respondent, both of those principles are violated. And of course, Article 40 does not say that it's limited to sentences. It doesn't say it's limited to trials. It is talking about generally the way in which children are treated when they appear before the criminal justice system. The other point I just ought to deal with, because I made reference to it, but it is important to highlight, is the case of the Queen on the application of Smith, which is at Bundle 3, paragraph 19, which deals with the point about children becoming adults. It's the, I accept a very different context. It is the situation where it was about the review of children, the review of minimum terms in the case of children sentenced to detention at Her Majesty's pleasure. And the argument, one of the arguments that was put was that a review in the particular facts of that case was inappropriate because of the fact that the child in that case had become an adult by the time that the claim was heard. And really paragraphs 12 and 15 at the bottom, around letter H, deal with that and make the point essentially that, of course, one of the reasons why you continue to review the position of a child when they become an adult is because at that stage it's easier to assess how much maturity has impacted on their development. And secondly, because ultimately an offence committed by a child is always that. It remains an offence committed by a child, and the child is entitled to be treated as somebody who offended when they're a child. In our case, we drew attention to a number of, I think that probably concludes all I need to say about children, and I'm going to go back to essentially the overall position, yes. and in particular look at now at one matter that is highlighted particularly in our case, which is other jurisdictions, and I'm going to take your lordship and ladyship to three jurisdictions in particular to demonstrate, hopefully, that what we argue for is actually common and found to be workable in a number of in similar jurisdictions. The first jurisdiction is Ireland, and I made reference briefly to it this morning, but it is worth looking at. And the Irish statute is in Bundle 10, it's tab 103. And the Irish provisions are set out in the Sex Offenders Act 2001 for attention to the age of the Act, because if the review mechanism is impractical, one would assume that it would be amended by now, as far as I'm aware. And the review mechanism, the key, two points really that I feel in relation to that arise in the first respondent's case. Firstly, Section 8 of that Act sets out the period of registration. And it's worth noting that it draws a distinction between children and adults in that children are subject to a maximum period of 20 years, whereas adults can be registered for life. But more importantly, perhaps, at paragraph 11, section 11 rather, one sees the provision that's allowed them to apply for discharge. One can't apply within the first 10 years. And then the text is, and set out in section 11.1, the test is whether the interests of the common good are no longer served by his or her continuing to be subject to the registration requirements. The interest of the common good, in some ways, is language similar, it's not identical to the language one saw this morning in relation to IPP necessity. It's a different way, perhaps, of expressing the same concept. So the Irish have a scheme where one can apply if one has an interest in the common good. The same bundle also has the Canadian Criminal Code.
So which provision is the common good one?
Sorry, it's 11.1. It's
11.1, sorry.
Section 11.1.
Yeah, thank you.
It's the last line.
Yeah, sorry, thank you.
I imagine there's some learning of the Irish courts as to what that phrase really means.
Overnight, honestly, we managed to get, partly because of the issue that was raised by my friend about the Australian system, the Australian learning and what their equivalents are. We haven't
Yes.
got anyone on the Irish code. We can probably find some.
Yes, don't worry.
We'll try and make sure we can get some.
Canadian?
The Canadian code is at 100. Have 100, same 100. Sorry, 99. Interestingly, if one sees this as Article 490.011(2), if someone is prosecuted as a child, and there are things that allow them to be prosecuted now, if the prosecution as a child, as a young person,
It's 99.
sorry, 99, it's not, have 99, yes.
So 99 is Canada.
Yeah.
Yes.
Sorry. Yeah.
Yes, sorry. It's the documents has two columns, one
Yeah,
in English,
yes.
one in French. Page 535, which is Article 490.011, subsection 2, is the exclusion that normally applies where somebody is prosecuted as a young person. And effectively says that registration doesn't apply, as we understand it, to young person prosecuted. But the key point, again, in terms of the review mechanisms, is section 490.015, which allows for an application to be made after a period of time which depends on the length of the registration period. In the case of somebody who is subject to indefinite registration, it's after 20 years, it's subparagraph C. And then paragraph 490.016 is the test that applies, and it's the test of grossly disproportionate, which we've seen from the case that's handed up this morning, is essentially the test that generally applies in other Canadian sort of rights. So again, it's a balancing test, essentially, similar to necessity. The New South Wales scheme, or the Australian schemes, as far as I can work out, are all identical, although they are enacted on a state-by-state basis. And the New South Wales scheme, as an example, is at Bundle 9. Bundle 9, tab 91. This was the scheme that my friend Serena made reference to in his submissions. And it is the scheme that, I should say, it is the scheme that deals with, or that imposes a test of not posing a risk to the safety of children. that is a matter that's being considered, certainly in other contexts, by the New South Wales Supreme Court. And the authority, one of the materials I handed up this morning is the decision of the New South Wales Supreme Court in Commission for Children and Young People against B, 2002 New South Wales Supreme Court 949. Dealing with a slightly different provision, we're not finding cases exactly on this provision, but dealing with a provision which has exactly the same wording. This is paragraph 8, a provision that required consideration of whether somebody does not pose a risk to the safety of children. And the approach of the New South Wales Supreme Court is set out essentially at paragraph 42 of the judgment. And the approach of the New South Wales Supreme Court is to look at it, is to consider whether there's a real intrusive risk, in the sense that the risk is greater than the risk of any adult preying on a child. So one sees there a range of approaches, and as I indicated this morning, we would accept that Parliament would have to debate if this claim succeeds, what is the correct approach, what is the approach that strikes the correct balance. But in all these cases, all these jurisdictions, there is the ability to assess individual risk. And the ability for the individual to come before a court and say, the risk I pose doesn't justify the burden that's placed upon me. And so one can see there that one doesn't need to have the sort of system that one has in the United Kingdom. One has workable examples, apparently workable examples, from a number of jurisdictions. And in that context, in my submission, one needs to recognise as well, again, that in the course of this litigation, 6 experienced judges, who are all, presumably, because of their criminal experience, used to assessing risk and used to dealing with risk, used to managing risk, have all thought that there are cases which could be assessed by a risk assessment mechanism by a court as being ones where the registration requirements are no longer necessary. So I think that probably sets out fully our positive case, and I just need to deal with the issues that are made by the appellant. The first thing that's said is that weight needs to be given to the views of Parliament. Well, of course, in principle, weight needs to be given to the views of Parliament, but the exact weight depends on the context. And here, the critical point that the European Court has made is that there need to be adequate legal safeguards to ensure that the justification of the retention of data remains valid. And assessing whether legal safeguards are adequate is something the court has competence to do, because it's assessing the adequacy of legal safeguards. This isn't an area where Parliament is being made an assessment of a political decision. Legal safeguard, the adequacy of legal safeguards is something the courts assess all the time. In that context, reference is made to the fact that there was a debate, and one's already heard this, there was a debate and an amendment in fact submitted by Alan Michael, and we circulated the text of that debate from Hansard this morning. And it was an amendment, in fact, that would have allowed both for an extension and reduction in the period of registration, so that it sort of reflected the sensitivity of the case. And what we say about that is this. If one looks at paragraph 63 and 64 of Wilson, it's clear in principle that one of the uses that Hansard potentially can be put to is that it can be relied upon as a statement of evidence, essentially. If material is presented, to use an example, if the government, for example, produced a white paper before this, which had demonstrated that the cost of a review mechanism was £100 million, instead of presenting a white paper, the government minister had stood up in Parliament and said, well, we've researched this, and we can tell Parliament that the cost of introducing a review mechanism would be £100 million. Well, Nicholson case that's irrelevant. And that makes sense, because when assessing proportionality, if evidence is given in Parliament, one can see how that would be relevant. The problem is that the reason why the debate in this case is relevant is, in fact, what one gets is no evidence to demonstrate why a review mechanism would work. What we now have, of course, is with this time, the position has moved on in the sense that we're now a number of years further down the line, and one knows that from one's jurisdictions, there are jurisdictions where review mechanisms are working. One knows, looking at our jurisdiction, that there are review mechanisms that work. And so, when one goes back to the debate in Parliament, one sees the fact that there was no evidence, essentially, cited by the government when they opposed the Michael, and then Gavin Michael amendment. The difficulty, the reason why Hansard is relevant is because when the burden is on the Secretary of State to demonstrate proportionality, there is nothing in the debate in Parliament that goes to assist that demonstration of proportionality. Dealt with that fairly quickly because I am conscious of time, but I hope that makes our position clear on this relatively issue of what needs to make Hansard. The issue that I just touched upon, which is the burden being on the Secretary of State, is relevant generally when one looks at the evidence, because ultimately, when one looks at the evidence to justify the Secretary of State's position, one comes back to the report of Jenny Cann. And that essentially says that if one takes a group of sex offenders, one can see that statistically, within a certain period of time, that a number of them will reoffend. But that can't justify the absence of a review mechanism in circumstances where there are a number of examples that have already indicated of review mechanisms that work. And ultimately, the real issue is, has the Secretary of State justified the burden supposed upon him to demonstrate proportionality? And in our submission, particularly in the context of a situation where the European Court has repeatedly emphasised the need for individualised risk assessments. The Secretary of State says that the review mechanism will have significant resource implications. We don't accept that's the case, necessarily the case for three reasons. One can always impose restrictions upon the number of applications. One's seen the Irish system, for example, where one can't make an application for 10 years. Secondly, to an extent, at least, it may be possible to impose court fees. And thirdly, there must be costs associated with administering a scheme that includes people on it who don't need to be on it. And these matters are presumably reasons why foreign jurisdictions all appear to be able to operate review mechanisms. But even if I'm wrong about that, even if it's obvious to have resource implications, we say that that's not the answer anymore, because the basis of the learning from submission is essentially the judgment of Lord Steyn in the S. and Marker case. And ultimately, one of the reasons why S. and Marker in Strasbourg is relevant is because it demonstrates that approach was wrong, in the sense that the resource indications don't justify the absence of an individualised review mechanism. And that's, in some ways, one of the key differences between the approach the House of Lords took and the approach that was then taken in the European Court. The arguments about resource requirements didn't justify the absence of a review. What about case law that relies upon? Adamson and Massey, we say fundamentally, are admissibility decisions, and they're admissibility decisions that proceed both to Boucher Court, but perhaps more importantly, almost because it's the part of the principle that apply in Boucher Court, proceed S. and Marker. It's true, obviously, in Massey there was reference to a complaint about the lack of a review. There's no reason addressing it, and one can see that on the facts of that case, the lack of a review may well not have struck the European Court as being significant. The applicant in question remained in custody at the time, and so had not been in a position to demonstrate that he could trust the reviews. In any event, as I say, they predate Boucicault and Martin. Similarly, Gallagher and the Scottish ministers, but the judgments both predated Boucicault and Martin. And in my submission, essentially, they are, perhaps not surprisingly, because they predated those authorities, inconsistent. They firstly failed to take account of the significance the European Court attaches to the retention of data and interference with our claim. They, on the face of it, appear to regard the interests of the European mind. They failed to take account of the importance the European Court attaches to the The significance of that, in some ways, can be shown by looking at the A judgment, where in the A judgment, it was acknowledged that there could be circumstances where requiring someone to register would be disproportionate. And one sees that in paragraph 52. The alternative accepted that you could conceive of circumstances where the obligation was disproportionate. And ultimately, the distinction really between the approach that was taken in Gallagher is that, and the approach that was taken by the European Court, is that Gallagher, the focus was essentially on overall benefit to the system, justifying justifying interference with individual rights. Whereas Marper and Boucicault emphasise the fact one needs to carry out an individual assessment of rights in individual cases. If one doesn't do that and have safeguards to ensure that balance is right, the system will be disproportionate. The other cases cited, which are Forbes and the Queen against A, essentially consider different issues. So, in summary, and I'm conscious of the time, but I think my target for myself is the right time. We say that the learning friend hasn't identified any reason for going behind the clear message that's now been sent out by Strasbourg, which is one needs to have a mechanism to ensure that people do that. Yes, I can insist.
No, thank you very much. Mr. Straw. Mr. Owen.
My lords, my lady, I of course gratefully adopt all of Mr. Southey's, if you like, generic submissions on Article 8. He of course has developed separate arguments on the basis that his client is a child and they don't apply to Mr. Thompson, but I adopt obviously all of the other arguments. And I make six short points. Firstly, no rational basis for distinguishing on the review issue between adult and child. Secondly, deference. Thirdly, the Strasbourg cases. Fourthly, a look at a couple of cases that deal with the test that the parole board applies to the statutory test. Fifthly, a short point on Ms. Crasati's evidence. And sixthly, to show you one recent statute, the Safeguarding Vulnerable Groups Act 2006, which introduced the barring procedure as a recent example of a statute which has a review procedure in it. So firstly, it is our submission that on analysis there is no rational basis for distinguishing on the question of review between the position of a child and an adult. The Divisional Court and the Court of Appeal drew no such distinction. In fairness, of course, Mr. Eady draws no such distinction. He says the same argument applies to both, and he doesn't acknowledge any different rationale. And it is our submission that that is and must be the right approach. Bright lines are, of course, an acceptable method of lawmaking, and indeed one might say they are a necessary feature of lawmaking. My Lord Clark referred, for example, to the 1991 Criminal Justice Act, which introduced, for the purposes of the release scheme, a distinction between people serving less than 4 years or more, or life sentence prisoners, and different legal consequences flowed between the automatic release scheme, the discretionary release scheme, and so on. And for present purposes, we draw no, there's nothing improper about that. But where due process requirements are the focus of the argument, then in our submission, rigidity is a very hard principle to defend. And the Secretary of State's submission is, on analysis, an extreme one. it is that there is a group of people whose position can be identified at the point of sentence, for whom there can never be any review of the need for the imposition. That is, in our submission, an extreme proposition, and where one is looking at due process requirements, one would expect a very, very compelling justification to emerge, because on the face of it, fairness can never be inimical to the effective operation of any scheme. It is difficult to see how a review process can ever undermine any particular legal scheme. On analysis, my learned friend's submission breaks down into three justifications for the scheme. Firstly, the very operation of a review process would undermine the legitimate aim, because the tool of a complete database, which is never deleted in the case of a group of people who fall within the more serious offenders, that is an end in itself, and therefore a review process is inimical to that operation. That's really his main argument. The second argument is a cost argument, and the third one is, I think, really that it's pointless anyway, because no one could operate a review scheme by reference to the test which he says would be operated, and therefore, for those three reasons, a review process should be rejected. And I won't repeat the points that Mr. Southey has made in relation to that. The point about the arguments for a child in our submission is that the child arguments turbocharge the argument that a review process must be in place as a matter of Article 8 proportionality. The stark facts of imposing lifelong registration or notification on a person who commits an offence at the age of perhaps 11 or 12 exposes vividly the disproportionality of a scheme which can keep such a person, despite no further convictions, on the list potentially for 60 years. Once that argument, assuming it is accepted for present purposes, is an unacceptable balance, striking of the balance, one then is in the position of seeing how those very same arguments, which are really arguments about rehabilitation and the capacity for change that all human beings have, they then engage in the case of all persons. The possibility of change does not end on our 18th birthdays, fortunately. And all of the arguments then flow naturally in favour of a review process, because otherwise one's in the situation of the 16-year-old who commits a very grave sexual offence, justifying a life sentence or an IPP, and then you have the child who or the person who reaches 18 the day after, commits an offence which only just gets into the 30-month bracket, and then they are on lifelong notification with no possibility of review. And in my submission, therefore, the child arguments are powerful arguments in exposing graphically the disproportionality of an unreviewable notification scheme. But once that is accepted, then in effect, the same arguments must apply logically to all people. So that's point one. Deference. Could I just say something about the withdrawing of the amendment? I think you have now the debate in the Standing Committee where Mr. Michael eventually withdrew his amendment. And in my submission, not least for the reasons that my Lord Clerk mentioned, the withdrawing an amendment, particularly in this context, cannot be read as in any sense showing that Parliament had given consideration to the scheme which was ultimately enacted. And perhaps that's an obvious point to make. But particularly in this field of sex offenders, the most unpopular group of individuals it is possible perhaps to imagine. And one can see why perhaps there are not lots of members of Parliament queuing up to table amendments to introduce fairness for this particular group. And so the circumstances in which this particular amendment was withdrawn really establishes nothing in terms of showing that Parliament had considered in a reasoned way and rejected the possibility of due process.
I mean, should we say, well, Parliament didn't give proper consideration to this matter? I mean, is that not doing exactly what we were told we're not to do, question the proceedings in Parliament?
But Lord, no, precisely not, because all I'm saying is that the amendment was withdrawn. Parliament never addressed its mind to the issue.
If the amendment's put forward and it's not supported, I mean, if it had been supported, it would have got proceeded. It would have gone to a vote.
Well,
I mean, people withdraw amendments because they realise that there's no support for it. I mean, that's what happens.
well, as you'll see, if you read the section in columns 27 to 29, I think, of that, in effect, it was on the understanding that the minister was going to go away and reflect and so on, and he withdraws the amendment.
Yes.
But the real point...
He didn't put it down again.
No, he didn't.
No.
He did not. He
So
didn't.
there's no support. I mean, that's how these things happen. I mean, you're not going to find anything more than that, Mr. Owen, and that if we're looking at withdrawing amendments.
Well, Lord, the real point, perhaps I needn't have approached it through the example of saying that sex offenders are an unpopular group. The real point is that Parliament didn't debate it and reject it because there was nothing to debate. And the real point here, perhaps, is the point that Mr. Southey's made, which I needn't repeat, which is when you look at the context of the debate, there was no evidence before either the committee or the House when it implemented the 1997 Act. And of course, when the 97 Act was introduced, there was no need to give a Section 19 statement of compatibility. The 2003 Act, in effect, continued the pre-existing scheme. And of course, I accept there was a statement of compatibility to that Act, but in the context of the 97 Act, that no one had really addressed their minds to that issue. Could I also show you on the case law, of course, Wilson and First County Trust has been looked at, but could I just draw your attention, remind you of what was said by Lord Steyn in A number 2, the rape case in 2002. It's, I think, with the usher.
Thank you.
And my lords and my lady may recall the context of... do you also have Horncastle and others? Yes. It's Crown against A number 2. This was the case which challenged the compatibility of Section 41 of the statute, which placed limitations on the ability to cross-examine a complainant in a rape case. And the only point is paragraph 36, Lord Steyn's speech, where he, by reference to Brown and Stott and the reliance of the Secretary of State on the the discretionary area of judgment, went on to say that clearly the House must give weight to the decision of Parliament that the mischief encapsulated in the twin myths must be corrected. On the other hand, when the question arises whether in the criminal statute in question Parliament adopted a legislative scheme which makes an excessive inroad into the right to a fair trial, the court is qualified to make its own judgment and must do so. Now, of course, I accept it was a criminal case, it was an Article 6 case, but the exercise which the House then undertook was a classic proportionality exercise, as you'll see in the next few paragraphs, by reference to De Freitas and so on. The point is that this was a fair trial case. The question here of due process requirements in the context of the need for safeguards in an Article 8 case is equally within the competence of the court. The courts are experts in due process, and this court is qualified to make its own judgment in the absence of compelling evidence that the Secretary of State is able to rely upon as to whether there is a need in a scheme such as this for some element of review. The Strasbourg case law, Mr. Southey has made the point about Massey. Could I just draw your attention, volume 6, at tab 51. Just to hammer home the point, this case got to the admissibility stage very quickly, perhaps unusually quickly. You'll see it was introduced in March 2002, and the ruling came out within a year. And at the very beginning, on page 2 of the facts, at that stage, Mr. Massey was currently still in prison in HMP Acklington. he'd had a sentence of 6 years, as we've seen already on page 4. And so in those circumstances, if one then goes to page 9, towards the bottom under the complaints, the reference to his complaint that he is subject to the registration requirements under the Sex Offenders Act and that there's no assessment or review of the necessity of registration in his particular case. Now the question is he complaining there of the fact that when the sentence was imposed upon him, there was no assessment of or review by the court of the necessity of registration in his particular case? And bearing in mind that the man was still in prison, it's overwhelmingly likely that that is what his complaint was. It was the automaticity of the measure which was the part of the complaint. There could be no assessment or review of that necessity in his particular case. And so when, at the end, on page 12, in brief terms, without any reference to case law on due process, safeguards, need for review of continuing necessity, the court refers to Adamson and correctly identifies it as a case which was simply considering whether the requirement to provide information to the police under the 97 Act constitute an interference. The court then refers to that case and concludes, in Roman 3, the court concludes that the same assessment applies on the facts of the present case. But on the face of it, the reason the same assessment applies is because the complaint was the same. It was the fact that the requirement was being imposed automatically without any review by the court. And so, quite apart from the fact that it's an admissibility decision, logically, on the face of it, although we haven't got the full details set out here, it looks as if it was a complaint about that automatic application. On Bouchercourt, the reason I've put Horncastle in is because when my learned friend Mr. Eadie first introduced Bouchercourt, he referred to what Lord Roger had said in AF number 3 about Strasbourg has spoken, the case is closed, and so on. But then suggested that this might be a case for a dialogue between this court and Strasbourg. Now, and two members of this court were in Horncastle, but could I just draw your attention to what Lord Phillips, in his judgment of the court, for the court, said between paragraphs 9 and 11. This was the case involving the challenge to the hearsay rule in the context of whether there was a sole or decisive test for the operation of Article 6 and whether there should be the consequence of an unfair trial under our 2003 Act. And the court rejected that, but in very particular circumstances. And one sees at paragraph 11 where Lord Phillips rejected the submission that the same approach should be taken. The requirement to take into account the Strasbourg jurisprudence will normally result in this court applying principles that are clearly established by the court. There will, however, be rare occasions where this court has concerns as to whether a decision of the Strasbourg court sufficiently appreciates or accommodates particular aspects of our domestic process. In such circumstances, it's open to this court to decline to follow the Strasbourg decision, giving reasons for adopting this course. This is likely to give the court the opportunity to reconsider the particular aspect of the decision that is in issue, so that there may take place what may prove to be a valuable dialogue between this court and the Strasbourg court. Now, in this context, Mr. Southey has made the point, which I submit is entirely correct, that Bouchercourt is building on MARPA. And it's not clear what my learned friend Mr. Eadie is suggesting in terms of the dialogue. Is it suggested that the dialogue is purely about whether the principles in Bouchercourt, which is the first occasion that the Strasbourg court has looked at a registration system in sex offender cases, should not apply because our system has some particular unique quality which may not have been appreciated by the Strasbourg court, because in my submission that's really an impossible argument to run. But more importantly, here, the principle, if Mr. Southey's submission is right, as I submit it is, the real principle is paragraph 103 of S and MARPA, which is the Grand Chamber saying that Article 8 requires there to be, in domestic law, a method of reviewing the necessity of a continuing interference with Article 8 rights. And in my submission, there is no need for any dialogue about that principle. It then is simply an application of that principle to the particular facts of the scheme. Fourthly, the test applied by the parole board. You've seen what the test is in terms of the statute. Could I refer you to the case of Watson? I'm not sure if that's been...
Yes, we do.
You have that. Watson was a case in which the argument was that when the parole board determines the question of recall, it should apply a different test from the test it applies when it is considering whether to release someone in the first place. And that was rejected. And if one goes to the speech of Sir Thomas Bingham, as he then was Master of the Rolls, on page 916, there's a helpful expansion of what the practicalities of the parole board's task is. And it's really at H, having set out the reference to these were under the 1991 Criminal Justice Act provisions, which are now replaced by the Crime Sentences Act, which you've already looked at. But Lord Bingham said at H on 916, in exercising its practical judgment, the board is bound to approach its task under the two sections in the same way, balancing the hardship and injustice of continuing to imprison a man who's unlikely to cause serious injury to the public against the need to protect the public against a man who's not unlikely to cause such injury. In other than a clear case, this is bound to be a difficult and very anxious judgment, but in the final balance, the board is bound to give preponderant weight to the need to protect innocent members of the public against any significant risk of serious injury. This is the test which the statute prescribes, and I think it's equally appropriate under the other section. And Lord Justice Roach said something very similar at 919F to H. And so that's the test that the board applies. It gives preponderant weight to risk to the public, but it doesn't deprive the board of the ability to form an assessment of risk in all cases. And of course, sex offender cases may give rise to particular difficulties of balance, and no doubt statistical evidence and so on will be relevant. But that is the practical test which the parole board applies.
This kind of, I mean, there the two things are: you either deprive the person of his liberty,
Yes.
or you release him.
Yes.
And the balance is between depriving the person of liberty and the threat,
Yes.
the risk to people.
Yeah.
Here, the balance will be between continued notification proceedings.
Yeah, of course.
No, sorry, just
Yeah.
does that mean that one would? I mean, how does that affect the risk? I mean, would one take the view that since this is by comparison with depriving of liberty, it's a less burdensome thing. Therefore, one would say, well, one should take a lower threshold of risk. In other words, is that how one would do it?
Well, it would primarily spring, assuming that the appeal succeeds as a declaration, the appeal fails and the declaration is upheld, then Parliament will have to address its mind to what the test that whichever body has to apply this.
When we're going this line,
Yeah.
I mean, if you're balancing two things, I mean, if it's a relatively, by comparison with deprivation of liberty, a relatively minor
Yeah.
interference, would one therefore say, well, in that situation, one would say, well, one wants to take less of a risk with the public.
It might be said to be a relevant factor. At the first review, you might think, well, he's been on it for 10 years, and it may be justified, bearing in mind the nature of the obligation to keep it going for another 5 years. But then at the 15-year point, then it becomes harder to justify. It would be difficult for me to stand here and say it would be wholly irrelevant.
I'm just asking this.
But yes, yeah. No, I certainly wouldn't be able to suggest that type of thinking would be wholly inapt. One has to look at all points as to whether the extent of the interference with the Article 8 right is justified by an assessment of the realistic risk the person presents in the light of all the relevant information. But my point in showing you this was really just to show you that it's not just the wording of the statute, that the case law has actually given a practical illustration of how, in reality, this form of risk assessment is worked out. And it's a test that's applied clearly by the parole board in the context of sex offenders as in the context of all other serious offenders. While we're on that, and could I just, for your note, without taking you to it, Lord Bingham said something very similar about the question of bearing in mind that someone has behaved in a very violent way in the past in the context of murder, refer you to Lichniak, which is the case about whether the mandatory life sentence was compatible with Article 3. That's Volume 2, Tab 10, at paragraph 16. He said something very similar to what he had said in Watson about, if you like, the precautionary principle that a risk-assessing body applies. Fifthly, and very briefly, it may be I just need to remind you of it, because Mr. Eady didn't actually draw your attention to it specifically, but Jackie Christ-Satty's witness statement, which for present purposes is at 215 of the appendix. My Lady Baroness Hale drew attention to the categorisation statistically of types of offending, of course accepting that there's no rigid compartmentalisation and some people then go on and commit a different type of offence. But in terms of the practicalities of risk assessing, it is surely permissible and would be permissible for anybody required to apply its mind to it to take into account the fact, for example, that the evidence shows very low risk in relation to intra-family offenders with female victims. It is a statistical reality. It's relevant to the exercise that the board, or whatever it was conducting. And draw your attention to the similar point that's made there in the context of age and reconviction in paragraph 15, and then her summary in paragraph 16, where she makes the point, again, about intra-family offenders, acknowledges the difficulties in the fact that there's a low detection rate, but then her main conclusion in the middle, however, even with these adjustments, low-risk offenders, as defined by the RM 2000, remain low risk at around a 10% reconviction rate, reflecting differential motivations and typologies, but most, but not all, sexual reoffending occurs within the first 10 years in the community, and by 15 to 20, reconviction rates are negligible. Now, you've seen from other schemes that it would be overwhelmingly likely that for those subject to the indefinite scheme, Parliament would be very likely to say that no one can have a first review until 10 years, at the earliest. And so if you are a person who has remained completely conviction-free for 10 years, it's obvious from this type of general statistical evidence, albeit with the imperfections or elements of doubt based on unreporting and unrecording of convictions, but nonetheless, it's another relevant factor. It's got to be relevant to the picture that the person is presenting. And lastly, point 6, could I draw your attention, volume 8, tab 71, to the recent act, the Safeguarding Vulnerable Groups Act, which was part of the machinery that had been introduced in the wake of the murder of the 2 young girls in Cambridge, the Soham murders and the Bishard inquiry and so on. But here you have a statute which is making, as you'll see from the title, making provision in connection with the protection of children and vulnerable adults. It sets up the body known as the Independent Safeguarding Authority by Section 1. Section 2 deals with 2 types of barred lists which are established and maintained by the body, a children's barred list and an adult's barred list. And Section 3 sets out the implications of that, barring a person from regulated activity in relation to children or vulnerable adults. Section 4 then deals with appeals. An individual who is included in a barred list may appeal to the upper tribunal, 1C, in relation to a decision under paragraph 17 or 18 of that schedule not to remove him from the list. And then it sets out the test that the upper tribunal applies to the refusal to remove somebody from the particular barred list. And if you go then to Schedule 3, paragraph 18, which is on page 77, top right-hand corner, this is paragraph 18 of Schedule 3. one sees the review process there set out, a person who's included in a barred list may apply to ISA for a review of his inclusion. A person may apply for permission only if the application is made after the end of the minimum barred period, and then the prescribed period ending with the time, and so on. ISA must not grant permission unless it thinks the person's circumstances have changed since he was included in the list or since he last applied for permission, as the case may be. And then 5 is the test. On a review of a person's inclusion, if the ISA is satisfied it's no longer appropriate for him to be included in the list, it must remove him from it. Otherwise it must dismiss the application. And so now this list it goes back to the point that my Lord Hope made.
But that isn't subject to appeal, is it?
Yes, it is.
Well,
it's
forgive me. Just explain to me. The ground is that it's no longer appropriate.
Yes.
Under Section 4, subsection 3, the decision whether or not it's appropriate for an individual to be included in a barred list is not a question of law or fact.
But there is firstly the right to go to the independent safeguarding authority to be removed. There's a review to that extent.
Yes.
And then you appeal 4.1c, a decision under paragraph 17 or 18 of that schedule not to remove him from the list.
Yes, but you can only do it on the grounds of a mistake on law or on a finding of fact. And for the purposes of that, the question of whether or not it's appropriate for the person to be on the list is not a question of fact or law.
My lady's quite
so
right.
it's a very limited
Yes,
right
it is
of
a very
appeal.
limited, it is, I accept that. The upper tribunal's jurisdiction is limited. But the real point of this is that the ISA, which on the face of it is an independent body, is capable of reviewing the matter. And the point about this scheme is that it can involve people who are unconvicted. In other words, you can get on the barred list without being convicted. And so the point that my Lord Hope made by reference to the L case does apply. But one has the situation here where undoubtedly you get on the barred list because you have a sexual offence, you have the conviction. And you could have the situation in which you can't apply to have yourself removed from the sex offender register because you're indefinite, but you could apply to have yourself removed from the barred list, despite the fact you have a conviction. Now, that would be, on the face of it, an absurd situation, and it is, in my submission, strong evidence to show why the suggestion that this is an impractical, impossible, and ultimately pointless exercise is not an argument that should be accepted. My Lords, my Lady, that's all I propose to say, unless I can assist on any other matter.
Thank you very much, Mr. Witham. Yes.
My Lord, I think it comes to me now to make some brief observations as an intervener.
Yes. We've read your case, which gives us a very clear picture of the Scottish proceedings. Of course, we're interested in the English proceedings.
Absolutely, so Lords. I will be brief. First of all, I would apologise for the length of the written submissions. It was because it was done at such short notice. I didn't have time to make something shorter. In the sense that getting clearance to come here and legal aid meant we had a fairly short time. I think most of the issues are, in fact, answered in that. Just a couple of brief points that have arisen in the oral submissions. The question of Hansard was raised in A against the Scottish ministers, and there was some argument about when and how that could be looked at. And the submissions which I put forward were set out in paragraph 22, which of A against Scottish ministers, referring to Wilson, saying that really one ought to be looking at the words of the statute rather than going behind it, because if you do in fact go behind it, what in fact will result is greater confusion. There are 11 documents which the Lord Advocate is holding in readiness in here. One looks at those, not just at snippets and gobbets of them, but the whole thing. You seem to in fact see a shifting legislative aim from protection of the public sometimes to protection specifically of children. And that aspect of the shifting aim is perhaps relevant to the question of the proportionality of some of these measures. For example, the restriction on travel at some levels is aimed at the scourge of sex tourism, but it's sex tourism against children. But it applies indiscriminately to all kind of offenders, including in the case of the child who committed sexual offence while he was 14 against two adults. The justification which is given by the Lord Advocate in terms of the Scottish provisions illustrate this, in terms of the notification of all changes in your bank accounts or of any bank accounts held by a business unincorporated association. We're told, in fact, that about results out of Operation OR, which was to do with the downloading of child pornography. But again, that applies to everybody on the register. There isn't a specification, a focus upon the particular scourge of the sexual abuse of children. The Hansard extracts seem to then move. Sometimes it focuses on sexual abuse of children, sometimes it focuses on general protection of the public, sometimes it talks about risk assessment, but it doesn't enlighten in any way at all. So, if anything, it undermines the other side's case. But in any event, proportionality of the legislation has to be judged here and now against the whole background, which is not just the legislation that's passed in 1997, but all the regulations which have subsequently occurred, because it's how the impact occurs upon the individual. And so one can't separate the regime into primary and secondary legislation. Brief point in terms of the quality of the law which these provisions impose. They impose various restrictions upon pain of possible conviction and sentencing up to 5 years imprisonment. We have seen the difficulty which Mr. Reedy has had in actually tracing what those obligations might be. What happens if you weekend in Scotland and sometimes in England? How many days do you need to notify individuals at the police if you're going off on a long weekend? Which police stations do you have to go to? It's an incredibly complex morass of obligations which open up those subject to it, as I say, to prosecution if they fail in any way at all. The quality of the law then, in terms of the restrictions in accordance with law, because of that complexity, also has to be, come into question in terms of the assessment of the proportionality.
Is it the practice for the individual to be given a handbook so that he can find his way about all of this?
Not to my knowledge, certainly. That's never been suggested in our
Instruction.
And the issue is, of course, it's not simply about getting the information, it's how the information is got. Since 2000, it's always to do with going in person to the police. Going in person. It's not that they need the information, but there's a symbolic, as it were, go to the police, say it in person aspect, which again impacts upon questions as to the proportionality of and the aims of this legislation. One of the issues which was suggested by my friend Mr. Eady was that the question of usage of how this information, having been collated and retained, doesn't impact upon the proportionality. But, in fact, when asked, when he stated that one of the aims of the legislation is protection and prevention, the example given of how does one prevent crimes is by using the information, is by disseminating it, by handing it over. So it is an essential element that within this scheme, as outlined by Mr. Reedy, that there is dissemination. He says, but one needn't worry about that because it's all covered by public authorities have duties of confidentiality and the like. But we've seen, and it's been mentioned, and it's something which has caused the Inner House some concern, is that there are pilot schemes in both England, Wales and Scotland for the handing over of information to members of the public.
This is Sarah's law, is it?
Is that the idea? And that's ongoing in Scotland, in Tayside. The legislative basis for that has never been clarified. We've asked the Scottish ministers for that, but we haven't had a response yet. And that's a matter which, again, is coming back before the Inner House once I've had the opportunity of looking at.
Is there any evidence about the way in which this material is disseminated, or the extent of the dissemination of it since, say, 1997 or 2003? There isn't. None of the evidence really addresses that, does it?
It does not, and these serious law things that have been said to be pilot schemes
No, I'm not asking about Sarah's law, because that's something different. I'm talking about the statutes with which we are directly concerned.
In terms of who's had the information?
Yes, well, how many times it's been passed and to whom, and do we know, it's said to be very important and so on, but is there any material before the courts, at any rate, about that? There isn't, is there?
The only information is that the MAPA schemes which were set up in 2005, which are to do with local agencies coordinating. They were duty to make arrangements to monitor sex offenders within their area. There's not a duty, as these are matters which were submitted on behalf of the Lord Advocate. There's not a duty to make an individual assessment.
I'm not asking about the duty. I'm asking about the facts, as whether there's any evidence of fact about the extent of the use made of the material held on these registers.
There are MAPA reports which have been put in before the Inner House, certainly for Scotland, which show the extent to which authorities have coordinated and created a picture of sex offenders within their area, and they publish reports annually, collating the information and having out statistics. But that's the only information which I have. So that's the I understand that, at least in England and Wales, there is some guidance given to sex offenders in a rather large group, but it doesn't seem to be complete and an accurate statement of what the obligations are, which in terms of the travel obligations. I don't understand there to be anything similar within the Scottish. Just a small point on Massey, which has already been looked at. The other point to note about Massey, it was brought in 2002, and it refers to, as the court stated in Adamson, there's no problem with the 1997 Act. What is not brought out is that the 1997 Act had changed by the time that the court was considering matters in Massey. The notification requirements had been reduced from 14 days to 3 days. The requirement of notification had been required to be in person rather than by letter. And the travel restriction regulations had come in. None of this was noted by the court. Presumably this was a matter considered on the papers only, and they thought we were dealing with the same act. So it's a flawed decision in and of itself, because it doesn't even accurately reflect the state of the national law at the time, which apparently are giving the perimeter of proportionality in terms of the automaticity requirements at the time. So it's really of no particular weight. Lord Roger raised in the discussions of Bushaku the fact that it's rather difficult because the applicant Bushaku had not raised the Article 8 point and had just raised an Article 7 point. In fact, in MB against France, which isn't produced but was part of the same 3 cases on the same day, the Article 8 point was raised by the applicant, but the court's reasoning is almost precisely the same terms that necessarily but the emphasis in Bushakur, as we say, is on the triple protections provided by the administrative procedure of applying to Procureur de la République and then to the and finally, Lords, the aspect of remedy in Scotland, I had thought from indications given on behalf of the Lord Advocate there'd be some discussion about remedy in the Scotland Act, which is why it goes into some detail in the written case. Clearly, that's a matter which the Inner House are going to consider when they reconvene on this matter. The declarators of the approach which the Scotland Act takes raises issues of some complexity and constitutional importance, but it's not something which need detain this court, particularly on the basis that the declaration of incompatibility formally from this court is binding over England and Wales
Thank you very much, Mr. Perry. Yes, Mr. Eady.
My Lords, a couple of points I made by way of reply. Firstly, in relation to Bouchacourt, my learned friend Mr. Rowan took you to the Horncastle case, and I think one of you noted that the statement of principle set out in the relevant passage of Horncastle referred to the domestic court ordinarily giving effect to, quote, clearly established Strasbourg case law. And you'll appreciate that my submission in relation to Bouchacourt, it is not that evident, and it's for that reason that I've taken away in my submissions the question mark after Makutum. And there is therefore still a considerable scope for dialogue where it should be. As far as Mr. Southey's submissions on Bouchacourt are concerned, it is perhaps worth bearing in mind the contrast between the position as far as we understand it in Bouchacourt and the position as it exists domestically. In relation to both jurisdictions, there are principles that the retention of data should not be excessive in scope too much. There is also a principle in both jurisdictions derived from the European legislation, the European directive to that effect, and also recommendations of ministers to the same effect, which should not be held for an excessive period, for too long. This is unclear to us why the court in Strasbourg appeared to be placing central reliance on recommendations from the Council of Ministers, when there were in fact, or there is in fact in existence in any event a European directive, which is included in our black bundle, which covers very much the same ground in relation to the retention of data. But in any event, under both jurisdictions, there are those principles are in play. Certainly in domestic law, both of those principles are in play, because the European directive has been brought into effect and transposed in domestic law through the Data Protection Act, which does contain both of those principles. So in principle, it is possible in the domestic jurisdiction to challenge, to review the retention of data on the basis of either or both of those principles. The question then is, what in context does that enable the person to challenge in our particular context? And the answer to that is that in our particular context domestically, a challenge can be made under either or both of those principles to the retention of conviction information. That indeed was based on the challenge on the basis. It would in principle also allow, under the Data Protection Act, a challenge to any other information held by a public authority, including, for example, what I call the wraparound information. But, as I acknowledged in my earlier submissions, the answer to a challenge to the wraparound provisions would be, no, I'm terribly sorry, Parliament has set down the scheme which requires notification. And therefore, to the extent that the information is current, the wraparound information is current in status and remains useful, Parliament has given you the answer. And I accept that in relation to that category of information, that would be a complete answer to any challenge under the Data Protection Act. It doesn't remove the right of review, still less does it touch the right to review the retention of conviction information. But it would operate in relation to current status and continually useful information as a complete answer. But that description indicates that there may be some historic wraparound information, for example, which it would not be relevant to retain. For example, an uncontentious travel which occurred 3 years ago or 4 years ago that continued to be retained. There would be a right of review in relation to that information, and the justification burden would rest on the public authorities to justify its continuing retention. In other words, the existence of this notification regime would only operate to provide a complete answer to part of such a challenge. But the more fundamental point is that one has, under domestic law, a right of review. Now, the purpose of setting out that is to enable one to make a true comparison with the position as it was in Bouchacourt and to put properly into context paragraphs 66 to 68 of Bouchacourt. Firstly, because like in Bushacore, as in Bushacore, there are under domestic law rights of review, and they cover very much the same territory as the right of review covered in Bushacore. By which I mean that in Bushacore it appears that the challenge to retention, the right to review that was accorded under French law, applied both to conviction information and to what I call wraparound information. So it's not as if one comes at Bushacore and says, well, goodness, there was some enormously wonderful right of review in Bushacore and they need all this information and there's no equivalent in the United Kingdom. The true comparison is that the disparity, as it were, between the French regime and the English regime is really a very narrow one. It is simply in relation to a part of the wraparound information in the United Kingdom, where it would, as I've accepted, be a complete answer to refer to the notification regime under the Sexual Offences Act 2003.
When one's looking at, I find these paragraphs 667, 68 quite difficult, but just so that I'm clear, Mr. Eady, when it says, for example, that the length of time for which it's retained, so in one view, I mean, if one takes marker, then of course, once it was on, it was there for it could be there for many, many years. And it was just the same information. It was the DNA or whatever it was. Here, of course, every year, a fresh little piece of information goes on. Now, I take it you're not saying that makes a difference. In other words, new every year isn't an answer. You don't say, well, it's only been on for 1 year. You know, the address, supposing he's changed his address, and it's now, first time it's gone on is 2009 or something like that. One doesn't say, when one's considering how long this is going on for, so the paragraphs on length of time, you don't say, well, his address in Kensington has only been on for a year.
I don't say that as a complete answer.
So that's what I'm trying to say. Are you saying it at all? That's what I was trying to get
Well,
at.
it is relevant, this is the point I was making, it is relevant to acknowledge that the only information you couldn't challenge domestically would be the information which remained current and remained useful. So you would, if you're comparing the rights of review, have a right under the DPA to go off to the Information Commissioner and say, of the wraparound information, some of it is current and obviously useful. For example, the new address, the information which is no more than a year old. But in relation to other types of information, the historic information, you could mount the argument. Now, it's not to preclude the police from saying in answer to any such challenge, well, it remains useful because it shows us travel patterns and so on. But you would have an argument. It wouldn't be shut out. My point is that the shut out under the domestic law is narrow. I don't say that's a complete answer necessarily, because this regime does last for...
Would the Information Commissioner, in a challenge under the that Act, in relation to historic information, would he would have power, would he, to direct the removal of that from the register, notwithstanding the provisions of the 2003 Act?
He would have power to remove...
I suppose you went along and said, well, they've got all my historic addresses. I've been living my present address for the last 10 years, and it's quite irrelevant for them to know where I lived 25 years ago. I want it removed.
Well, my understanding is yes, because there is nothing in the 2003 Act which excludes the operation of the Data Protection Act provisions. There is a provision, as you recall, in section 94 in relation to that very special regime of bouncing to and fro to verify, that says nothing in this shall disobey the Data Protection Act in effect. But retention remains governed by the Data Protection Act.
But you couldn't go to the Commissioner and say, this information is irrelevant because I'm no longer a risk.
No, you couldn't.
Why not?
Because you would still, that would be the premise on which the 2003 Act continued to apply to. So you couldn't go to the information...
Even though that was the premise in relation to historic information, that was the premise upon which it was being held. You could make the case, could you, if you were the applicant, which would be potentially valid at any rate in relation to historic information, but not to current information.
Yes, I mean, I think the dividing line would be that the Information Commissioner would not be empowered to order anything which would undermine the operation of the 2003 Act. Otherwise, he'd be acting in a way that was contrary to a piece of primary legislation. Now, you can have an argument about precisely when you reach that point, but my submission would be that you would reach that point if you were seeking to either remove current and useful information provided in the last.
Even if you could show that there was no risk.
Right.
Suppose you persuaded the Information Commissioner that there was absolutely no risk in the applicant's case.
Then you would undermine the 2003 Act. Because then you could go on to the Information Commissioner and say, I can't do it under the 2003
Well, because under the 2003 Act, on its true construction, it contemplates retaining information, even though it can be shown there's no risk.
Well, then we get back into that argument. The question is whether that is the premise of the 2003 Act.
But that would be the logic of that being part of the premise of the 2003 Act, namely that, even in a case where you could show and satisfy a court, say beyond a peradventure that there was no risk, nevertheless, the Information Commissioner couldn't order the release of the...
Well, one can take this logical extreme and posit that proposition.
Well, this isn't such a logical extreme. We've got it logical extreme, but some may think it's not so extreme.
Well, I'm not going to go back.
No, we've argued. No, but I'm just interested in, because I hadn't appreciated how far the powers of the Information Commissioner might be relevant.
As I say, the premise on which my submissions are founded in relation to the 2003 Act is premised on the idea that you don't get in relation to the most serious offences, you don't get to that point. And I accept that in exchange with discussion with Phillips, that if you get to the point where you can satisfy someone that there is no risk whatever, then certain logical consequences follow identified in the Court of Appeal's judgment. The question is whether that's a correct premise to be offered.
Mr. Reid, forgive me because I'm sure you have already told us and I've just forgotten. If I toddle along to my local police station and give my information in, what happens then to it? I mean, where is it going to be when the police, somebody wants it? Where is it going to be? Is it going to be on some national database, or where is it going to be?
Let me double check. I'm not sure I know the answer to that. I haven't told that.
Right.
Not the PNC, it's a database which is available to all, I think called Visa or Visa.
Right. So it's a national database.
So any police officer in any police authority area can access it.
Yes,
That's the idea.
that's my understanding. I suspect that it may have been as a result of one of the recommendations.
Yes, indeed.
Yes, absolutely.
That's right,
yes,
indeed.
Then he went to another county,
Yes.
known about it that county, and then he went to Cambridge and killed the two little girls.
Yes,
Yeah,
yes, that's right.
exactly.
So it was precisely to avoid, as it were, state-run policing. That one of the central recommendations of Bishop was that one should set up computer databases which were, and deliberately were, so accessible. So I accept, of course, that it widens the access to the information.
Yes.
Potentially it widens access to misuse that happens.
And is there a public scheme? I mean, is that in the public domain, all that? That the existence of the...
It is now.
Well, it is now, yeah, but... I mean,
There is,
Well, I think it is. I think it is well known that there is that.
so in that respect, it's like the French system, because they have a national thing, as I understand.
But there is still the objection of, I don't know how these are done in the police station, but you may find yourself in the local police officer beside somebody who knows you and hears what you're there for. I mean, I don't know whether this all takes place in a sort of back room where you can be kept out of the public gaze, but there is this problem of people having to go through this procedure. And it's not about the release of the information of where he lives. Probably everybody knows where he lives in the area, but the fact that he has to go and report it is the problem.
On my Lord's example, the police has public authorities that are obliged, as every other public authority is, to comply with ECHR laws. If a person turned up to the police station wishing to hand in information, they were in a public place, and the information was to be handed over, and the police officer refused to accept it unless it was shouted across the room. Then it might be thought that there would be a pretty compelling case that was an abuse of power by the police officers. This information is designed to be provided to the police for a particular purpose. And the police, I'm sure, are well aware that they cannot demand they are well aware that there are serious limits upon them in relation to the use to which that can be put. So, of course, I accept that as a theoretical possibility, but considering the true possibilities of abuse of the system and the difficulties in which is that the court is entitled to assume and should assume that the police at all parts of the scheme will act lawfully.
Could I ask for two questions which are matters of detail? First of all, do we have anywhere the qualifications of Jenny Can, apart from the fact that she's a public, she's a senior research officer?
That's not all found in the appendix, I suspect not, but we can certainly make some further inquiries. Let me see whether she put them in her article.
Don't think so.
No, I recall correctly that she had a star next to her name. I'm in the title of the article she wrote.
Yeah.
But that was simply a direction of correspondence star rather than her qualification. Although if it's a matter of importance, we can certainly...
It's not a matter of great importance, I'd just like to know.
If you would like it, we can certainly provide it.
Thank you. And the other question is this. The aspect of notification requirements that has struck me as being potentially the most exacting is travel notification. If you envisage somebody who spent a lot of his time going to and fro out of the country. And that is under Section 86 of the 2003 Act. And that provides for notification to be given in accordance with regulations, which we have at flag 77. But I may have missed it, but I can't find any indication as to how the notification is to be given. And 87, Section 87, which deals with notification, applies to Sections 83, 84, and 85, but not on its face to 86, unless it was amended. It does seem to me far from reasonable to expect somebody to go into the police station every time he's changing his travel plans.
Until the Regulation 10 of the I remember that in the bundle in relation to Scotland, there was a provision at the back of the relevant regulation which dealt with the manner in which you notified the travel.
It's tab 87, I think. It might be in volume 9, tab 87. That's the one about travel.
987.
That's a
The
Scottish one.
That's the Scottish one, indeed.
That's the Scottish one.
Yeah.
It's Regulation 10 of the Scots.
Yes.
It's not.
That deals with that.
The English one is... English is 77, I think, is it?
Yeah, it's tab 77. I haven't managed to find anything in it about how you notify.
What I've been told is that may be a misprint in the electronic version, because in the version I've got in front of me, it's exactly the same regulations, and especially thanks to that guidance from CJS, there is an equivalent to the Regulation 10 in the Scottish one. So the answer to my Lord's question, I think, is that there is the equivalent of Regulation 10 in the Scottish one, which is in the bundle, and we will undertake to provide you with an accurate version of that. We will be very honest, if
It would be.
in all our respects and identity
Yes, yes.
suddenly departed from each other on that. But there is a Regulation 10, and we'll make sure it's provided.
Yeah.
Bouchacor, the final point on Bouchacor is that in relation to the England and Wales, as in the position in France in the Bouchard case, is that one does have, certainly in relation to the most serious offences in the United Kingdom, consistency, as it were, between the conviction information and the rapportage information. Now, of course, in the context of England and Wales, there may be disparity between them in the context of the finite periods, but at least in relation to the most serious offences and on the way the conviction data is currently stored.
Well, consistency in one case, but the conviction data that has to be stored is not simply sexual offence conviction data, as I understand it, but other conviction data which doesn't have anything wrapped around it.
Well, that's true. That's true in relation to other offences, but at least in relation to the most serious sexual offence category, one has, as it were, a consistency between conviction information detection systems and the wrapper. And we've noted with unease, but it was lowest, Mr. Sully's statement that Bouchard might well open up the possibility of a challenge in relation to the retention of conviction information. The purpose of this hearing, all one perhaps needs to know about that, is that it implicitly, if not expressly, acknowledges that in Bouchard the information in question included, just the review included, conviction information. So that's what I want to say about Bouchard. In relation to use, the positions between the parties are essentially that Mr. Southey and Mr. Owen say that the potential for use or abuse is a vice, and we say that use properly made, which is the assumption on which you must operate, is a virtue of the scheme. Indeed, it is the gateway, or can properly be viewed as the gateway into the sort of assessments that are undertaken as part of the matter exercise. Critical, not merely to ensuring that the public are properly protected, but also that the individual concerned is given the best chance. There is a matter of some concern, at least to me, which is that I have discovered in the last half hour that there should be, at the end of the appendix, additional material relating to the rugby league matter, where I think might have been a result of cut-off, and there's potential that that could be used as an example of a situation in which the information had been misused or controlled inadequately somehow. It concerns me because that little set of documentation hadn't actually come into my appendix. Maybe it is in my rules, my own 228 and following. You know that?
Yes, mine's been sort of pinned at the end.
As long as it's documented, that deals with the circumstances in which that information came out in the context of this individual.
No, I don't think that, well, I haven't found it.
Pages 228, 240.
Exactly.
Well, I was looking at the back of the core volume, but it isn't at the back of mine.
It is at the back of the appendix. That's it.
Yeah.
I beg your pardon, I've got it in the, yes, at the appendix, but not in the core volume. Yes, thank you very much.
Well, as long as you have it, that's
Yes.
fine. I'm not going to take up a lot of time on it, but
Right.
with respect to the appears, that, for example, from 229 paragraph 9, it appears that far from being a misuse of information, what this indicates is an entirely proper, thoroughly justified, protective use of the information. This individual himself properly applied, as I understand it, filled in a form and applied for the requisite clearance or operating the scheme, that it came from him, as I understand it, and as a result of that, various processes were worked through. And I don't think my own friend Mr. Southey is contending that the rugby league episodes, as it were, and the information coming out into their clutches for that purpose is in any sense an example of misuse or abuse of the system. And that may be a point of...
Sorry, how did it happen, Mr. I'm sorry.
He applied to join the
Yes.
club.
And how did they know about
As
it?
a result, he had to apply to join the rugby league or for clearance from the rugby
Yes,
league.
as part of that process, they were then doing authorised checks for the
Well,
type of...
we need to know, don't we?
Well, I'm afraid that's not in
Yeah.
my hands.
Yeah.
Not my client. This is a statement to put in, this is the material that you've got.
What we don't know is what the Rugby Football League
Yes.
did.
Yes, but it would be...
Whether that would be in the...
I mean, do they
Whether it
check
be in the
every
respondents.
young person who wants to join a club?
Well, if they're...
Every teenager who wants to go and play rugby with an outside club?
I don't know what
Do they check everybody?
I don't know what their practice is. 237 is the letter from the Rugby Football League.
Yes.
Is it just
I
a
bet
matter of
they don't.
practice, or is
I
it,
bet they don't.
something they're required to do?
I'd be absolutely staggered if they did. Any more than the rugby union clubs do.
The RFL Safeguarding Case Management Group.
No one, I just actually going to properly contend that the information of this...
Right, I'm just looking, March 28.
Yes.
The RFL received an anonymous phone call informing the RFL that a registered sex offender had registered for Chevington Sharks.
That's where I got it from.
May 2007. Also,
Yes, yes.
Yes. From GMP. Who's GMP?
very much the case.
Yes.
The short point is there. Some submissions were made in relation to the licensing scheme. And the position in relation to licensing schemes, in relation to parole board dealing with detention matters more directly, in relation to borrowing schemes, and in relation to mere provision of information, simply illustrates there is a variety of degrees of intrusion, degrees of interference, depending upon the nature of the state of the individual. We don't submit and have never submitted that courts in a variety of different contexts, including in the context of detention, do not have to engage in a risk assessment. That, however, is not the issue. The question is whether Parliament was entitled to set the balance where it set the balance in the context of this case, where, however you characterise the experience in question, it is undoubtedly very considerably less in terms of interference than the case in relation to any of the other examples of the country, notably and specifically detention or the continuation of licensing. Certainly licensing which carries with it a degree of supervision and active involvement. And there was some discussion between those representing the Lord Advocate and Lord Clerk about that in relation to those who are level one. Certainly we, on behalf of the Secretary of State, don't accept that the mere fact that you are on level one means that the interest of the state diminishes boundary in terms of public protection and in terms of the provision of information as to your future whereabouts or movements. Matter goes down, as Melanie friend rightly pointed out, only the low risk and not the no risk. But one can think of a series of concrete examples where a person ceases to be subject to active supervision and intervention, but where it would nevertheless be useful and desirable in order to achieve the legitimate aim of public protection for information as to, for example, a change of address to be provided to the authorities. One only has to posit the example of a serious sex offender who done his time and comes out, has been subject to supervision for 5, 10 years, however long it may be, he drops to level one, so there is no longer persistent day-to-day active interest in supervision, and then notifies the police that he's decided to move, and he moves from an area which is perceived to create no risk whatever, for example, to a flat directly overlooking a girls' school, and he moves into the flat which is directly above a person with whom he used to consort and who is also a known sex offender. And those circumstances, again, bearing in mind the Canadian examples, that in that sort of situation, might be thought to be perfectly obvious that the police would wish, for proper public protection reasons, to have access to that information to enable them to make an assessment, a revised assessment, as to whether or not they did actively want to get involved with this information, and to make assessments about whether he should continue to be level 1 or to be moved up to level 2.
Well, more generally, I can see the police saying that if a sexual offence is committed in our area, we'd like to be able to ascertain very quickly if there are any close residents who've got a record for sexual offending.
Well, we would certainly accept that. That is focused very much on the detection aspect.
Yes, but if you detect, you prevent the next offence.
Do. I was trying to come up with an example which was more directly preventive. So there hadn't been an offence in the area, because I was aware that certain rules that aspect of it. So the example I give perhaps goes rather more directly to prevention, but I entirely accept my Lord's point. If you wanted a series of perfect sensible examples which go to detection. As far as the comparative position in other states is concerned, in relation to that, the point is a short one. There are other systems in place, entirely properly drawn to this court's attention by my own friends, which do make a provision in a whole variety of different ways for some sort of review. There are judgments which will need to be made in each jurisdiction as to what is perceived to be, in their particular individual circumstances, an acceptable level of risk to the public. And that is, in my respectful submission, a perfectly properly a national decision, and perfectly properly a matter for Parliament, and is not demonstrated to be disproportionate or irrational simply by pointing to the existence of other parallel and different systems in other different jurisdictions. In relation to Adamson, Massey and Gallagher and A and so on, I've already made the submission that we is properly decided and properly reasoned. We do not accept the purported distinction of Massey, which my own friend Mr. Owen sought to advance. Of course, it is right that at the time of the application, the question in Massey was in jail. But I think, from memory, he was sentenced to 6 years, and may well therefore have been out in 2. I think the conviction and sentence happened around about 1999. So on the cusp of being released and the decision was given. But in any event, it is clear, given the nature of the sentence that he received, 6 years, that he would have been subject to the indefinite notification regime. And if he was capable of looking forward as far as the hypothetical child that my learned friend Mr. Southey posited, which seems probable, he would have known full well that he would have been subject to the notification regime for the rest of his life. More importantly, however, if one is seeking to ascertain the intention of the Strasbourg Court, the passage to which you've now been repeatedly taken to page 9 can, in my respectful submission, be read only one way. It refers to a complaint about an assessment, there being no assessment or review. And it is clear that he was complaining inter alia, not merely about the automatic application of this regime, but about the fact that it was a review. And it does therefore stand as direct Strasbourg authority in the way of the conclusions which my learned friends advocate. Nor do we accept that it is appropriate or acceptable to seek to distinguish a case on the basis that it is an admissibility decision. Of course, if a decision is purely an admissibility decision, strictly sensible, that means that the court has not yet made up its mind finally. On the other hand, if the decision is an inadmissibility decision, as both Adamson and Massey were, that means that the court has decided that the case is so clear that it does not need to go to a full hearing before they can properly conclude that there has been no violation. And that is the position in relation to both Massey and Adamson. So we don't accept that ground of distinction. Finally, my lords and my lady, we come back almost to where we started. The ultimate decision for this court is whether or not Parliament rationally and legitimately struck the balance in the right place, specifically in relation to a regime that applied an indefinite notification regime to the most serious offenders, the most serious people who've been convicted of these going to go back over all the points I made in relation to legitimate aim, but all those points in my respectful submission do provide what my learned friend Mr. Erwin was demanding, namely a very, very compelling justification for the imposition of a regime as light, as relatively light as the notification regime, for the purpose of seeking to take whatever steps are possible for protecting the public. My Lord Hope rightly drew my learned friend's attention to that there have been a number of cases, numerous cases, in the past, and Ian Huntley is perhaps as good an example as any, where people are either come to the attention of the police or are acquitted time and again, and none of them are convicted, and yet 10 or 15 years later, longer periods after that, they then commence upholding offences. As I say, Huntley stands as a salutary lesson, and that sort of example in my respectful submission is an a fortiori case. It's a fortiori because this scheme does not apply to all those people. It only applies to those who have been convicted, and then not merely to those alone. Just the indefinite regime only applies to those who, in the court's judgment, warrant a sentence of over 30 months. So the most serious cohort within that convicted couple. And in my submission, this is a regime which properly and legitimately strikes the balance and properly to fulfil their protective function.
I'm sorry to detain you, Mr. Eady, but could you go back to page 237, this additional bundle in the appendix? I'm just trying to understand one of the several acronyms in this paper. It's in the May 2007 section near the top of the page, and it's the second paragraph there. The RFL decided, is where it begins. What is GMP?
Greater Manchester Police.
Ah, thank you very much. Yes. I should have worked that out.
It's not a guaranteed minimum pension, Mr. Eady.
I should have worked that out for myself. RFL I understand, but not GMP. Thank you very much.
The court is grateful for the assistance that it has received from counsel, both from this jurisdiction and from Scotland, and will reserve its judgment.